And I want to address the question of what an ERA amendment might accomplish in 2021 that hasn't already been achieved through other means. I know that Attorney General Herring will discuss the effort to get the ERA ratified and formally part of the Constitution. Virginia was the 38th state to vote to ratify in January 2020. So I'll talk about three other aspects of this issue. First, people ask, I've been asked, right, the Constitution already provides that, quote, no person shall be denied the equal protection of the law, end quote. And since the 1971 decision in Reed versus Reed, the Equal Protection Clause has been held to apply to sex discrimination. So why would there be a need for an additional constitutional amendment or constitutional provision that simply provides explicit protection when the Constitution is currently interpreted implicitly to provide protection? Here's one reason why. Sex-based classifications are not subjected to the same exacting level of scrutiny that the courts apply to classifications based on, for example, race or national origin. Courts subject those classifications to strict scrutiny. The government must demonstrate a compelling interest, and using the classification is pretty much the only way it can achieve that interest. So the means must be narrowly tailored to achieve a compelling interest. Measures that discriminate on the basis of sex, on the other hand, are subject to less rigorous intermediate scrutiny. In those instances, the use of the classification has to be substantially related to achieving an important government interest. So existing constitutional protection is weaker than it could be. Second, specific laws provide a measure of protection against sex discrimination, such as Title VII, which addresses workplace discrimination, the Pregnancy Discrimination Act, Title IX on educational equality, the Equal Pay Act. All of these address limited contexts rather than truly broad applicability. For example, both Title VII and the PDA, the Pregnancy Discrimination Act, only apply to employers with 15 or more employees. The PDA requires employers to give pregnant women the same sort of work-related accommodations they provide other temporarily disabled employees. It doesn't provide protections to women who suffer discrimination related to their childbearing capacity or because they could become pregnant. It doesn't protect women's equal rights to work and family simultaneously. Along the same lines, even though some 20 states have provisions in state constitutions prohibiting discrimination on the basis of sex, a number of those, including Virginia, don't interpret their provisions to provide a higher level of scrutiny than intermediate scrutiny, following the federal court's application of the 14th Amendment's Equal Protection Clause. In sum, these measures provide only patchwork protection, and they're subject to different lower levels of judicial interpretation and enforcement. Why can't federal lawmakers broadly legislate to guarantee sex or gender equality? Why are these federal laws so limited? Remember, the federal government doesn't have broad power to enact all sorts of legislation. It only has power to legislate pursuant to explicit constitutional authority, like through its power to regulate interstate commerce under Article 1, Section 8, or its power to withhold federal funds as a mean to encourage states to take certain measures. An ERA would give Congress authority to better address sex discrimination in employment, gender-based violence, etc. If we had an ERA in the Constitution, we might have seen a different outcome in the Supreme Court case Castle Rock versus Gonzalez, a 2005 case where a woman had a protective order that the police refused to make any effort to enforce when her former husband violated it by taking her 3 children from their front yard. The police ignored her, and her former husband ultimately shot and killed the 3 children, then drove to the police department parking lot and killed himself. The Supreme Court held the police department couldn't be held accountable because exercising discretion is something that law enforcement is expected and permitted to do. An ERA might have required the court to at least weigh the discriminatory effect on women of this law enforcement practice. We might have seen the Supreme Court at least weigh the discriminatory effect on women by religious for-profit employers like Hobby Lobby, who were permitted to exclude from insurance coverage access to contraceptives. And anti-abortion groups strongly oppose the ERA, in part for that reason. They see it as a way to expand access to contraception and abortion, saying the amendment could be interpreted to nullify federal and state restrictions. Finally, I think that the expressive effect of law is important, and particularly of principles enshrined in the Constitution. We see daily evidence of women being perceived and treated as less than equal, harassed in the workplace and on the street, assaulted, disbelieved when they complain of assault, and so on. An ERA would serve as a counter narrative, and it would voice our community's commitment to sex equality. We know that just being made aware of other implicit biases helps us to check and overcome those biases simply by forcing legislators, jurists, and all of us to consider sex equality and ensure compliance with that explicit commitment can help overcome it. Thank you so much for your time.